Good day, ladies and gentlemen, and welcome to the NCSL webinar, School Vouchers, Legal and Constitutional Issues. All lines have been placed on a listen-only mode or will be open for your questions and comments following the presentation. If you would like to submit a question at any time during the webinar, you may use the chat box located on the lower right-hand side of your screen. Simply type your message into the box and click on the send button. If you should require assistance throughout the conference, please press *0 on your telephone keypad to reach a live operator. At this time, it is my pleasure to turn the floor over to your host, Josh Cunningham, Policy Specialist, Education Program, NCSL. Sir, the floor is yours.
Thank you, and welcome to all of you joining us here today for this webinar exploring the legal and constitutional issues surrounding school vouchers and other private school choice policies. This webinar is sponsored by the Legislative Education Staff Network and the Legal Services Staff section at NCSL, and is also supported by the Walton Family Foundation. We will be discussing court actions at both the federal and state level that have shaped the school voucher policy landscape. My name is Josh Cunningham, and I am a policy specialist at the National Conference of State Legislatures. And my work focuses on school choice policies across the states, including their trek through the judicial system. In addition to myself, we have three outstanding presenters today that will be discussing the legal challenges that school vouchers have faced in their states. Ann Sabenfield is a senior staff attorney with the Legislative Council in Wisconsin. Alan Morford is an attorney with the Legislative Services Agency in Indiana. And Julie Pellegrin is the Deputy Director of the Office of Legislative Legal Services in Colorado. But before we hear from this great panel, I want to briefly go over the private school choice policies that will be discussed here today, as well as give an overview of the major federal court actions on this issue. Traditional school vouchers, as most of you probably know, are state-funded scholarships given to qualifying students who attend private schools. The majority of private schools in the country are affiliated with a particular religion, although there are a healthy number of private schools that are non-religious. But those private schools are typically what cause legal action to be taken against these policies. Personal tax credits are tax credits offered to parents as a sort of reimbursement for private school tuition that they've paid. They can also cover other expenses like transporting their child to the school and certain school supplies. And finally, tax credit scholarship programs are tax credits offered to individuals and or businesses who donate to privately operated nonprofit organizations, and those organizations use those donations to fund scholarships that they issue to students who meet certain qualifications dictated by the state. And those scholarships pay for private school tuition, and as well as sometimes can cover other expenses as well. The tax credit scholarship programs are unique. While similar to school vouchers, they're unique in that the funding mechanism of those programs has been detached from the government and the state and is completely handled in the private sector, which has pretty significant impacts on the constitutionality of the program. A quick look at the national landscape on these policies shows that 12 states have some sort of school voucher program. While this doesn't count Colorado, however, which has a district program, which has been initiated by the district and not the state, which Julie Pellegrin will touch on later. But not counting Colorado, there's 12 states that have school voucher programs. There's 12 states that have tax credit scholarship programs. And to give you an idea of how hot of a topic this has been recently, since 2011, 40 states have considered legislation on either vouchers or tax credit scholarships. And now I want to go to and review some of the major court cases that have occurred in the last 30 years addressing the issue of school vouchers and private school choice in general. And all three of these have been challenges to policies on the basis that they violate the Establishment Clause of the First Amendment, which you can see on your screen now. And so that has been the core of the arguments against these programs. The first case I want to talk about was in 1983. This is Mueller versus Allen. And this was a challenge to a Minnesota tax deduction offered to parents as a reimbursement for private school tuition. This was challenged by Minnesota taxpayers, and the court applied the three-part Lemon test from Lemon versus Kurtzman, which is required for a statute to comply with the Establishment Clause. And that Lemon test says that the government's action must have a secular legislative purpose. It must not have the primary effect of either advancing or inhibiting religion, and it must not result in an excessive government entanglement with religion. And so the court found that the Minnesota law passed this three-part test, and it established an important precedent going forward, and that was that when states offer aid, such as the tax deduction in Minnesota, that aid is going to the parent, and then it's the parent who makes the free choice whether or not to use that benefit for a religious or a non-religious school, therefore removing the state as playing a role in that decision of what school the money goes to. And that precedent was really important in the 2002 case of Zellman versus Simmons-Harris, which was a case where Ohio taxpayers were challenging the Ohio pilot voucher program in Cleveland. And as you can see, in 1999-2000, that school year, 96% of the participating students in the voucher program were attending religiously affiliated private schools. And so the taxpayers who were challenging the law were claiming that parents do not have an actual free choice because they can only essentially choose among religious schools. So they don't necessarily have the choice of attending a non-religious school. Now, the court disagreed with that in the end, citing, again, using the Lemon test, finding that the program was, despite that fact that the program was enacted for a secular purpose, simply for providing educational assistance to low-income students. And they agreed with the Mueller decision that parents have the free choice to choose whether or not to use the voucher at a religious school or a non-religious, and that the government's role, in fact, ends with the disbursement of benefits to parents and does not go any further than that. And finally, I'm going to discuss the most recent case, which was in 2011 in the U.S. Supreme Court, where Arizona taxpayers were challenging Arizona's scholarship tax credit law, and they filed suit against the Arizona Christian School Tuition Organization, which is a scholarship organization that issues private school scholarships and receives donations from private donors. And the challenge and the issue that the taxpayers had was that the scholarship organization, as you can see, I've provided a picture of the 2013-2014 school year application to receive a scholarship from this group. And as you can read in the description, this part is where the student has to write about a narrative about themselves. They are encouraged to discuss a number of different aspects of their own life, including their spiritual life. And what it shows is that, at least in Arizona and a couple other places as well, these organizations do sometimes consider the religious faith of a student when deciding who gets a scholarship. And even further, these organizations can limit which schools they offer scholarships to. And in this case, the Arizona Christian School Tuition Organization only allows their scholarship recipients to attend schools that are Christian affiliated. And those schools, in turn, can then, in their admissions process, also use the religious faith of a student in determining whether or not they accept that student into the school. And so that was really the basis of the challenge. And in this case, again, it was the taxpayers challenging this of Arizona. They were just general taxpayers. And they're claiming that, this tax credit that was being offered was in turn aiding the religious private school. However, the court in the end disagreed with this argument, saying that, in fact, as taxpayers, they do not have legal standing to file suit because a tax credit is not a government expenditure, and citing the Flass test, which was from Flass versus Cohen in 1968, they found that the taxpayers did not qualify to have standing in this case. Again, that if you were to rule that a tax credit is in fact a government expenditure, then you would rule that all income earned first belongs to the government, and then second belongs to the individual who earned it. And so the court said that that is not the case, and that the money never actually is possessed by the state, and therefore the taxpayer cannot claim any harm from that credit being given. This is interesting because it somewhat contradicts the Mueller case, which I first talked about, where it was a similar instance of general taxpayers challenging a tax deduction in that case, but the court never really addressed standing in that case and went straight to the merits and made a decision on the merits of that case. However, in this 2011 case, the court did not make any decisions on the Establishment Clause claim, and instead ended the ruling at the issue of standing. So with that, those are a quick overview of the federal cases, and I will next hand it off to Ann from Wisconsin.
Thank you, Josh, and I'm happy to be here today. I just want to say at the outset that I don't think I'll refer to choice schools mostly when I talk about the private schools participating in the voucher program, and sometimes I say voucher schools and private schools. So just at the outset, just to let people know that. In Wisconsin, we have had a school choice program for almost 25 years. Governor Tommy Thompson formally proposed a school parental choice program in his 1989 State of the State speech. And as you can see from this quote, the original idea stemmed from a concern that children in the city of Milwaukee were being failed by public schools. The program was originally only for children attending the Milwaukee public schools. Milwaukee is the largest city in Wisconsin, and like many large cities, struggles with issues related to poverty. The program began as a very small program. However, over time it has grown considerably with over 100 private schools participating and over 25,000 students participating. And the legislature estimates that the program will continue to grow in the upcoming years. Beginning in 2011, parental choice was also offered to students in Racine, Wisconsin. Racine is an urban area in southeastern Wisconsin. If you look at the statute authorizing the program, you will see that it was drafted to apply to any district that meets certain conditions. However, only Racine met those conditions at the time of passage, and the law is currently drafted so that it does not apply to any other school district. The program has been phased in over the last couple of years, but there will be no cap on the number of students who may participate beginning in the upcoming school year. The Milwaukee Parental Choice Program began as a program for low-income students. In the last Budget Act, however, the financial eligibility threshold for both Milwaukee and Racine was increased to 300% of the poverty level for a family, which arguably includes families that are not low income. Also, to be eligible, children generally must have attended school in the district or attended a private school participating in the choice program in the previous year. Students must be selected at random if there are more applicants than seats at the school, but siblings of current students may be given preference. Over the years, the legislature has enacted numerous requirements for private schools participating in the choice program. I'm not going to go through all of them, but you can see that in those private schools, teachers must have at least a bachelor's degree, and that the school must abide by discrimination and health and safety laws and must be accredited. Pupils in the choice schools must take the statewide assessments or standardized tests required of students in public schools, and each school must have academic and graduation standards. There are also requirements to monitor the school's financial well-being. And then current law also sets forth several standards for students in choice schools, and the school must meet at least one of them. So you can see it's a certain percentage advancing by one grade level, average attendance rate, significant academic progress, or parental involvement. In Wisconsin, the state pays the majority of the cost of students in choice schools. If our current budget bill passes as currently drafted, the state share of this cost will increase, as will the per pupil amount paid for students. The current payment per pupil is $6,442, which is lower than the average per pupil spending in Wisconsin public schools. As you can see, the cost of the program in Milwaukee was approximately $154 million in 2012. The statute establishing the choice program in Milwaukee was challenged in 1989 in Davis v. Grover on several grounds and was found to be constitutional. I'm going to talk about the Uniformity Clause and public purpose doctrine challenges because I think those may be most relevant in other states. The program was challenged as violating the Uniformity Clause of the Wisconsin Constitution, which requires the legislature to provide for district schools that shall be as uniform as possible. The required uniformity has been interpreted to mean uniformity in the character of instruction. The plaintiffs in Davis argued that the private schools participating in the program were district or public schools because they were funded with the state money and that they were offering instruction that was not in uniformity with other district schools. The court disagreed, finding that the legislature unambiguously referred to private schools in the statute and that the opportunity to receive a free and uniform basic education was not affected by providing additional educational choices to families. The court characterized the choice program as an experimental attempt to improve public education and found that students still had the opportunity to receive the basic education offered by public schools. The law was also challenged as violating the public purpose doctrine, which provides that public monies must be expended only for public purposes. The court found that the program had adequate oversight by the state superintendent and that parents would hold schools accountable so that the program would attain its public purpose. The program was again challenged in 1998 in Jackson v. Benson after significant changes were made to the program. One of the major changes was to permit religious schools to participate in the program. Also, there were more requirements for oversight placed on the private schools under the new legislation. Because of the addition of religious schools, the challenge in Jackson v. Benson focused on the establishment clauses of the U.S. and the Wisconsin constitutions, and again, the program was upheld as constitutional. The court analyzed the program using the Lemon test, which Josh described earlier. So for the first prong of the test, that the law must have a secular purpose, the court found that the program did have a secular purpose because the purpose is to provide educational opportunities for low-income students in Milwaukee. And for the second prong, the court found that the program did not have the primary effect of advancing religion because students were selected using criteria that had nothing to do with religious belief and that their parents chose how to direct their pupils' educational funding themselves. And then for the last prong of the Lemon test, the court looked at whether the state's requirements for the program amounted to excessive government entanglement. The court concluded that the oversight requirements in the program did not rise to a level to render the program unconstitutional because the regulations did not address schools' governance, curriculum, or day-to-day operations. The court also analyzed the law under Wisconsin's Establishment Clause, which contains the Benefits Clause and the Compelled Support Clause. The court found that the analysis regarding the Benefits Clause was the same as for the United States Constitution Establishment Clause analysis and noted that Wisconsin has traditionally accorded parents the primary role in the education and upbringing of their children. For the Compelled Support Clause analysis, the court considered whether the school choice program compels taxpayers to support a place of worship. Again, the court considered the voluntariness of the program and the fact that children are not required to participate in religious activities. And I want to close with just a couple of thoughts. Since Wisconsin has had the school choice program for so many years, the program has evolved, but it still remains very controversial. One issue the Wisconsin legislature may have to contend with is how far it can go with requirements for private schools participating in the program. While the legislature has the desire to hold the schools accountable, they are still private schools, and at some point there may be government entanglement in violation of the Establishment Clause. Some issues that may raise this issue are services to children with disabilities and how to measure academic progress of students attending private schools. The second thing I want to point out is that in Wisconsin, the choice program, I'm assuming, looks somewhat different than newer programs. In Milwaukee, many of the participating private schools very much rely on the choice program for funding, and about a quarter of the schools serve only children who are receiving a voucher under the program. So we are seeing children in a wide variety of private schools in Milwaukee especially. That is my presentation. Thank you very much, and I will turn it over to Alan.
Good afternoon. This is Alan Morford from the Indiana Legislative Services Agency, and today I will be talking a little bit about Indiana's Choice Scholarship Program. Before I do, I just want to mention three themes that come up in many of the cases revolving school vouchers, and those issues pertain to the amount of public control over the voucher schools, the proper use of public money, and the nexus between religion and the state. And depending on the particular state's constitutional provisions, the outcomes seem to vary with regards to the language that in those constitutions. As a general information, the Choice Scholarship was created by Public Law 92 in 2011. In Indiana, there's approximately 9,135 students who receive Choice Scholarships. The average amount of the Choice Scholarship is $4,083. The estimated total value is $37 million. The intent of the Choice Scholarship as it started out was to provide lower income kids that have attended a public school for at least 1 year with educational options. To be eligible, they must be a member of a household with an annual income of not more than 150% of the amount required for the individual to qualify for the federal free and reduced lunch program. For a family of four, this is approximately $65,000. This most recent session of the Indiana General Assembly made certain changes to the Choice Scholarship program. Some of the changes included that the General Assembly expanded the pool of students who would be eligible for the Choice Scholarship by including certain groups that are not first required to attend a public schools. These groups include children with disabilities who require special education, students who reside in an attendance area of a failing school, and siblings. This was added to avoid a situation with families of multiple children having children in separate schools. In addition, the General Assembly added language to provide that a student who initially meets the income eligibility requirements and whose household income subsequently increases remains eligible for the scholarship if the student's household income does not exceed 200% of the amount necessary to qualify for the free or reduced lunch program. Again, for a family of four, this was approximately $85,000. The state also provides special education money to follow the child if a participating school provides the student with services in accordance with the student's IEP. In addition, there were certain administration provisions changed during this last session. Since 2007, Indiana funding for public school operational costs come from the state as in the form of state tuition support based on the funding formula calculated using the number of students attending the school. This is important because this affects the amount of the voucher. In order to calculate the amount of the voucher, if the lesser of the tuition, a maximum of 90% of the state tuition support amount for the school corporation in which the student would be required to attend, or for grades 1 through 8, $4,500. And in this most recent session, the General Assembly decided to phase that up to $4,800. as I mentioned a bit earlier, since eligible students before the changes that become effective July 1 are required to attend at least 1 year in a public school, and at one point were included in the state count using to calculate funding, the state views this as a cost savings because school vouchers only cover up to 90% of the cost of a student's private school education. The state gets back at least 10% of the per pupil education funds set aside for those students that use vouchers. That remaining money is then pumped back into the statewide school funding formula. Last year, this was approximately $4.9 million. However, as I mentioned, since the General Assembly increased the student pool in this most recent session, the amount that will be saved will decrease as these students were never included in a school corporation's count. Okay, to be in a participating school, basically the eligible school must be accredited and provide basic curriculum requirements which are provided by private accredited schools in Indiana. They may not discriminate on the basis of race, color, or national origin. On March 26th of this year, the Indiana Supreme Court handed down its first decision regarding the Choice Scholarship Program. The plaintiffs challenged the Choice Scholarship using three arguments based on the Indiana Constitution. They challenged the Indiana Education Clause, the Indiana Establishment Clause, and Article 1, Section 6 of the Indiana Constitution, which provides that no money shall be drawn from the Treasury for the benefit of any religious or theological institution. In the plaintiff's first argument for Article 8, Section 1, which provides, it shall be the duty of the General Assembly to encourage by all suitable means moral, intellectual, scientific, and agricultural improvement, and to provide by law for a general and uniform system of common schools wherein tuition shall be without charge and equally open to all. The Indiana Supreme Court stated that the use of the conjunction "and" indicates that the General Assembly has two distinct duties. The first duty is to encourage moral, intellectual, scientific, and agricultural improvement, and the second duty is to provide a general and uniform system of common schools. Although the court acknowledged that the first part is a bit aspirational, they stated that it doesn't lessen the General Assembly's duty. The court also noted that under the school voucher program, the public school system remains in place. The plaintiffs argued that the voucher program could divert to private schools as many as 60% of the Indiana school children, and that the General Assembly would depart from the mandate of a general and uniform system of common schools. However, the Indiana Supreme Court disagreed and stated that even if this was true, so long as a uniform public school system equally open to all and without charge is maintained, the General Assembly has fulfilled its duty. The court also indicated that the plaintiffs had provided no evidence that the voucher program will necessarily result in the elimination of the Indiana public school system. In addition, the plaintiffs relied heavily on a Florida case, Bush versus Holmes, in which the Florida Supreme Court struck down a Florida voucher program based on Article 9, Section 1 of the Florida Constitution, which provides that it is therefore a paramount duty of the state to make adequate provision for the education of all children residing within its borders. Adequate provision shall be made by law for a uniform, efficient, safe, secure, and high-quality system of free public schools that allows students to obtain a high-quality education. The Supreme Court in Florida indicated that the paramount duty of the state was to make an adequate provision for the education of all children residing within its borders. In Florida, the plaintiffs showed that the violation of Section 1 by showing that the state was devoting the state's resources to the education of children through means other than a system of free and public schools. However, the Indiana Supreme Court noted that the Florida case distinguished its education article from the Education Clause in Wisconsin, which was discussed in Davis v. Grover by Ann a few minutes ago, which states that the legislature shall provide by law for the establishment of district schools which shall be as nearly uniform as practicable, and such schools shall be free and without charge for tuition to all children between the ages of 4 and 20 years old. The Indiana Supreme Court noted that Indiana's Constitution was in more comparison with Wisconsin than Florida and did not contain the adequate provision, and thus the plaintiff claim that the Article 8, Section 1 was violated failed. The plaintiff also brought an argument against Article 1, Section 4 of the Indiana Constitution, which provides that no person shall be compelled to attend, erect, or support any place of worship or to maintain any ministry against its consent. The plaintiffs focused on the phrase, or support. The court indicated that the plaintiffs argued that support includes the compelled payment of taxes that are used for religious purposes. The court indicated that the argument improperly expands the language of Section 4 because Section 4 is a restraint upon government compulsion of individuals to engage in religious practices absent their consent. The court said that the plaintiffs confused this with Section 6 of the Indiana Constitution, which limits government taxing and spending related to religious matters. Finally, the appellants argued that there was a violation of Section 6 of the Indiana Constitution, which provides that no money shall be drawn from the Treasury for the benefits of any religion or theological institution. The question that the court asked was, what does the Constitution mean by stating for the benefit of any religious or theological institution? To solve this problem, the court asked two additional questions. First, whether the program involves government expenditures for benefits of the type prohibited by Section 6, and second, whether the eligible school at which the parents can use the vouchers are religious or theological institutions as envisioned by Section 6 of the Indiana Constitution. For the first question, the court began by stating that it was inconceivable to prohibit all services to a religious or theological institution. For example, religious institutions receive fire and police protection, which may provide a substantial benefit to the religious institution. The Indiana Supreme Court stated that the proper test was to look at whether the institution received a direct benefit. The plaintiffs argued that the schools will directly fund the religious activities. However, the court found that the direct beneficiaries under the voucher program are the families of eligible students and not the schools selected by the parents for their children to attend, because the schools do not benefit unless the parents independently selects that school. Finally, with regards to the issue of whether the eligible school at which the parents can use the vouchers are religious or theological institutions as envisioned by Section 6, the Supreme Court focused on that last part, as envisioned by Section 6. They actually looked at the history of Indiana at the time the Indiana Constitution was adopted. The court noted that at that time, primary and secondary education was primarily provided by private or religious entities funded with public money and are not envisioned under Section 6 as religious and theological institutions. Thus, the Indiana Supreme Court unanimously upheld the Indiana Choice Scholarship Program. And with that, I will hand this over to Julie. Thank you.
Thanks, Alan. Good afternoon, everyone. This is Julie. And with this third part of this afternoon's program, I'm going to talk about how voucher programs have fared in Colorado and what that may say for your state. So, as you've heard, much of the debate and controversy around voucher programs is centered on the religious question. and that debate has also come up in Colorado. But before we get to that, I would like to remind everyone that there may be other provisions lurking in your Constitution that could restrict the legislature's ability to implement a voucher program. Both Ann and Alan have talked about challenges based on the constitutional duty to establish a free and, to some degree, uniform public education system. And as I'm sure you're aware, most states have language like that in their constitutions. The courts in both Wisconsin and Indiana and in Colorado, but apparently not in Florida, easily dismissed this concern by finding that a voucher program is in addition to the state public education system and doesn't interfere with the existing system. But beware, because there may be other restrictions or requirements in your state constitution that limit what the legislature can do concerning the funding for public education. For example, Colorado is one of only 6 states that have enshrined the requirement for local control of instruction in the state constitution. And just in case you're wondering, the other 5 states are Florida, Georgia, Kansas, Montana, and Virginia. So this is the constitutional provision, Article 9, Section 15, guarantee of control of instruction in the public schools of each district, that tripped up Colorado's voucher program. And you will note that the words voucher, funding, money, and religion do not appear anywhere in this section. So, what did the Colorado voucher program look like? In 2003, the Colorado General Assembly enacted the Colorado Opportunity Contract Pilot Program. As you can see in this slide, it was similar to other states' programs in that it was aimed at providing more educational opportunities for poor, low-achieving students enrolled in low-performing schools. Most importantly, the statute required each participating school district to pay a percentage of the district's per-pupil revenue to the participating private school, effectively requiring the district to use both its local and state shares of school finance money to pay for these vouchers. In Owens versus Colorado Congress of Parents, Teachers, and Students, the plaintiffs claimed that the Colorado Opportunity Contract Pilot Program violated several constitutional provisions, including all the provisions that prohibit governmental support of religion and religious institutions and the local control requirements. But the Colorado Supreme Court didn't even bother to talk about the religious provisions. They went straight to local control. Colorado courts have interpreted the school board's constitutionally guaranteed control of instruction as including control over any instruction paid for with locally raised money. The courts equate control of instruction with control of local tax dollars. The rationale being that control over locally raised funds ensures that the local electors can tailor educational policy to suit the needs of the individual districts, free from state intrusion. So the Colorado Supreme Court found that the Colorado Opportunity Contract Pilot Program was unconstitutional because it forced districts to pay for something, use their monies to pay for something that they did not control. And the court never even had to discuss the restrictions on state support for religion. Just to show this isn't just a Colorado thing, another quick and very recent example of a state-specific constitutional provision that can trip up a legislature's attempt to implement vouchers. Let's talk for a moment about Louisiana. The Louisiana Constitution includes this provision, Article 8, Section 13b, that directs the funding for public education in the state. The state board annually adopts the formula, the legislature approves it and must fully fund it, and then the appropriated monies are distributed to the state and parish system public schools in the state. In 2012, the Louisiana legislature created the Course Choice Program. They funded the vouchers by requiring the Department of Education to transfer to participating private schools monies from the minimum foundation program that otherwise would go to a student, city, or parish school system. The Supreme Court of Louisiana, however, interpreted Article 3, Section 13b as allowing distribution of the minimum foundation program monies only to public schools, not to private schools. So the court struck down the legislation as unconstitutional, again without resort to or consideration of any constitutional provisions addressing religion. All of this just to remind you to consider carefully any provisions you may have in your state constitution that direct public education, and especially any provisions that address the funding for public education. But now let's turn our attention back to the constitutional provisions that concern state support for religion and religious institutions, sometimes referred to as the Blaine Amendments. As you now know, Colorado doesn't have a state-level voucher program. But in 2011, the Douglas County School District Board of Education adopted the Choice Scholarship Program for students enrolled in the district. Unlike other voucher programs, this one was not born out of the need to help poor, low-achieving students get out of low-performing schools. Douglas County is a relatively high-income school district in Colorado, and it is fairly high-performing. Currently, it's accredited with a performance plan, which is our second highest level of accreditation. But the Douglas County School Board is very much in favor of educational choice. Although parents of Douglas County schools can already choose among all the schools of the district, can choose among several charter schools, and can choose to homeschool their kids, the school board wanted to provide more choice for parents. So, based on the recommendations of a task force, the school board adopted the Choice Scholarship Program. Private schools located within and outside of the district applied to participate in the program. Each school had to agree to satisfy a variety of eligibility criteria, including criteria relating to academic rigor, accreditation, student conduct, and financial stability. In the first year, up to 500 students were allowed to participate in the program. Their parents selected a private school, religious or nonsectarian, from the list provided by the district. Students had to meet residency and enrollment requirements, but there were no requirements linked to a student's academic performance or income. The district, this was kind of an interesting wrinkle. The district created a charter school to enroll the participating students for school finance purposes and to monitor students' class schedules and attendance, but the school doesn't actually operate as a school. Each participating student receives a voucher worth up to $4,575, which was 75% of the district's per pupil revenues for that year. A group of parents and taxpayers in Douglas County filed suit to stop implementation of the Choice Scholarship Program. On a motion for preliminary injunction, the trial court found that the program violates Colorado's Public School Finance Act and violates the constitutional provisions that prohibit government support for religion. The court, based on this finding, issued a permanent injunction to stop implementation of the program. On appeal, however, the Colorado Court of Appeals took a very different view from the trial court. The appellate court considered each of the constitutional claims raised by the parents and taxpayers and found for Douglas County with regard to each one. Also, just as an aside, they found that taxpayers do not have standing to challenge the implementation of the act itself or to bring a claim for violation. In looking at the constitutional provisions, the court clearly stated that it was not interpreting the Colorado constitutional provisions as being merely coextensive with the Federal Establishment Clause, but it generally followed the reasoning of the United States Supreme Court in the Mueller and Zellman cases that Josh talked about. So first, the parents and taxpayers claimed that the Choice Scholarship was providing support to religion in violation of Article 2, Section 4 of the Colorado Constitution. The Court of Appeals, however, found that since the program is facially neutral, there's no preference given to any religion. Also, since the parents are choosing to send their kids to a religious school, there's no argument that the district is requiring them to attend a religious school. Next, citing Article 9, Section 7, the parents and taxpayers claimed that the Choice Scholarship is using public monies to provide aid to religious schools. The Court of Appeals again disagreed. Since the district would pay money to a religious school only because of a parent's choice, the money was actually in aid of the parent and the student. Any aid that the religious school might receive is purely incidental. The parents and taxpayers next claimed that because some of the private schools required students to profess a certain religion and attend religious services during the school day, the Choice Scholarship Program violates Article 9, Section 8. Again, the Court of Appeals cited to parental choice. The student is only required to meet a religious test and attend services because the parent selected a religious school. The fact that the religious school is receiving a voucher that's paid with public monies does not convert the school into a public school and does not make the school subject to the restrictions specified in Article 9, Section 8. Finally, the parents and taxpayers raised Article 5, Section 34, which prohibits appropriations to private institutions that are not under the control of the state. Again, the Court of Appeals found no constitutional violation. First, this section applies to the state, not to school districts. Second, even if it did apply, the voucher is for the benefit of the parents and students, not the private schools. And third, under Colorado's public purpose doctrine, the receiving institution need not be controlled by the state if the district has a legitimate public purpose that is accomplished by paying the monies to a private institution. In this case, The court found that the district articulated not one, but three legitimate purposes: greater choice for families, improvements in public education through competition with private schools, and greater returns on educational spending. So, what do we conclude from Colorado's experience? A state-level voucher program that requires districts to pay locally raised tax dollars to private schools is unconstitutional in Colorado as a violation of local control. But, based on the Douglas County opinion, it appears that if the General Assembly were to craft a voucher program using only state dollars, the program would not violate the restrictions on governmental support for religious schools if parents had the choice to use the vouchers to enroll their children in religious schools. In terms of a takeaway for each of your states, it appears that any constitutional provisions around public education, and especially around the funding for public education, that are specific to your state constitution may actually be more important considerations than the religious support provisions that appear in your constitution. So I think we're now ready for questions. Josh, I'll send it back to you.
Thank you, Julie, and thanks to Ann and Alan as well for very interesting presentations. We want to open it up to some questions. If you look to the right-hand side of your screen, you'll see a little bubble icon at the top. You can click on that and submit questions through the chat window. I do want to point out that an astute listener has informed us that while the Louisiana Scholarship Program was deemed unconstitutional due to its funding system, the legislature has recently passed new legislation that changed the funding of the formula to address that issue. And our first question is, do any states have a limit to the percentage of voucher students attending a participating private school? For example, a school with 50% of its total student population made up of voucher students. Al, I know, Ann, you clearly in Wisconsin, it appears that that is not the case. Alan, do you know if in Indiana they have any provisions similar to that?
No, Indiana does not have any provision with regards to that, and I'm not sure of any state that does, but that doesn't mean there isn't one. It's just that I'm not aware. And
I'm not aware of any states that have put a limit on the number of students that can attend a single school now.
In Wisconsin, there is a proposal to expand our voucher program to statewide as different criteria, but it will be somewhat limited in the sense that initially only schools that are already in existence will be allowed to accept students, so that will prohibit a school from being established, just to accept voucher students initially.
Interesting. Great. Well, this next question is for Ann. It says, you mentioned the parental involvement expectation for private schools participating in the choice program in Wisconsin. What is that expectation, and is the burden similar for public schools?
I don't know that I have a detailed answer for that, but I think that the school establishes its own parental involvement requirements and then meets those. And I'm not aware of a similar requirement for public schools.
Okay, and we have one question about providing information, including bill numbers, on Louisiana's recently enacted legislation that responded to the court ruling. I can send that out to the attendees, and we can post that information. This webinar will be posted on the NCSL website. You can search our website for school vouchers, and it'll bring you to the school voucher page, and I'll definitely have a link there. And we'll definitely can add some information about the recent changes in Louisiana's law as well. Again, if you have any questions, feel free to click on the little bubble icon on the right-hand side of your screen and enter your question into the chat window. One question, do any of your states have data on the academic performance of voucher students? Are they doing better or worse than public students?
In Wisconsin, because the students in the voucher schools who are participating, who are receiving a voucher, so you have a private school and then the ones who are receiving a voucher, their scores on the standardized testing need to be reported to the state, and that information is compiled. You know, the raw numbers, it looks like the students aren't performing as well as statewide and even in Milwaukee. Now, there are arguments about that if you break down the demographics of the children attending those schools and how the comparison is, but we do have reports on the scores on the No Child Left Behind assessments that are required.
And I will say, just in general, research that has been done on the issue has been somewhat inconclusive. Some studies show benefits more for specific subgroups of students, such as low-income minority students tend to perform slightly better at certain grade levels while attending the voucher schools compared to similar students at public schools. There is evidence that participating students are more likely to graduate from high school, but you know, that's always a difficult question for research to answer, is whether or not students perform better in one school versus another, especially considering private and public schools are vastly different from each other and very different student populations. And in a lot of states that have these programs, there isn't necessarily a requirement that the schools administer a state assessment that can be compared equally with public schools. Our next question is, have there been any challenges to requiring voucher students to participate in state testing programs? As in, I assume that means would be such a requirement that they participate in the state testing be an overreach and create some sort of entanglement.
In Wisconsin, I'm not aware of any challenges, although parents can opt their children out of the testing.
Alan, has that been an issue in Indiana at all?
No, that is not an issue, because currently accredited non-public schools in Indiana take the statewide testing. So for the voucher, there wouldn't be an additional requirement. That wouldn't be an issue in Indiana.
Great, thank you. Our next question is, do any states other than Indiana have a limit to the amount a student's income may increase after being in the program?
I know that in Wisconsin, when it used to be that people who participated their family income had to be 150% of the poverty level, and then they were allowed to go up to, I think, somewhat over 200%, but I'm not sure if we currently have that requirement now that we're up to 300%.
I know there's some states, at least, that have considered legislation, I can't think off the top of my head if any of those have been enacted, that essentially say that you have to have that, the certain income percentage once you get the scholarship, but once you start participating, you're eligible for the remainder of your K-12, career, regardless of the increase in income. And one question was about whether the PowerPoint will be available online, including the recording. The recording of this will also be available in addition to the PowerPoint. Our next question is, how have state courts viewed state aid that results in the startup of schools in the context of a Blaine Amendment or an Establishment Clause challenge? It seems the direct benefit is limited to an inquiry of who makes the choice of school rather than the issue of 100% public support of a private school. Is that right? What about that 25% of fully funded private schools in Wisconsin?
That has not been challenged in Wisconsin. So I'm not sure what that challenge would look like or how we would how that would be framed. And I'm not sure how many of those schools are associated with a religious organization as well. I haven't looked at that. I think one issue which is somewhat related to this that I wonder about in the long run is, will there be a point at which there are enough of these schools outside the public school system that you do start to run into problems with other parts of your state constitution about the uniformity and character of the education, or the either Board of Education or the state superintendent's authority to direct public education. I think that there could be a tipping point as we have more of these schools and a greater percentage of the students attending these types of schools.
And I'll add that I'm not sure, outside of Wisconsin and the Cleveland program in Ohio, the other voucher programs, I'm not sure they've really been around long enough to have some of the issues that we're seeing in Wisconsin, of these schools that are 100% voucher students. And so it'll be interesting to see as time progresses in states like Indiana and Louisiana whether we see, as those programs mature, the same issues arise.
I agree with Ann with regard to this is Julie, with regard to the tipping point issue. It seems like if you got to a certain percentage of your students, even if you had a certain percentage, like in Colorado, if we have 178 school districts, and if 50, 60, 70 of them decide to run voucher programs for a significant percentage of their students, perhaps at that point you do have a zero and uniform issue.
And I have a question for Ann and Alan. The district-initiated program in Colorado is pretty unique. Is that something that perhaps a district in one of your states would want to implement in addition to the state program, or would that even be an option? Or perhaps in Wisconsin, where it's limited to just a couple areas, is that something that you think would be allowed under your state constitution? Or is Colorado somewhat unique in a district's ability to do that?
This is Alan. For Indiana, since the school's funded at the state level, the operational cost, I don't see it happening on a district level just because of the way of our funding is set up. However, I can imagine in other states where funding is done locally, that could be an option.
Yeah, I think in Wisconsin, the Constitution provides for the state oversight and talks about that of the district schools. And so, although there's a great deal of local control, I don't think it would be a violation of our Constitution necessarily. But I'm not sure that a school district would be interested in doing that just with issues of funding, and I think they'd be more likely to do a charter school that is run by the district. They have that flexibility.
And Julie, do you see the Douglas County program, if it does end up, coming out of the legal challenge as a winner, do you see other districts in the state following suit?
At this point, I would be surprised. I don't think Douglas County, like I said, is relatively unique in its board being so pro-choice. They're very adamant about, and that's the only district that I have heard of that goes that far. Most of the other districts are much more concerned about money getting siphoned off to charter schools, and I can't see them intentionally siphoning more money off into vouchers.
Our next question is, have there been any cases where schools that receive vouchers have denied high-needs special education and or behavioral issue students?
In Wisconsin, the students, and I think this is true probably in all of the voucher programs, students must be selected at random. And then, like we said earlier, they have to comply with the non-discrimination laws. That being said, in Wisconsin, we did have a complaint filed with the U.S. Department of Justice by a number of parents saying that their children had been discriminated against. And the types of allegations are that when you get to the school, they say, well, we really can't serve your child, or they have can't maybe deny based on behavioral issues. So there is that allegation. And the Department of Justice did write a letter to our Department of Public Instruction saying that they had to help schools comply with the American with Disabilities Act. That was fairly recent, so I don't know what's going to come of that. But the special education students in these schools is an issue because those the parents give up the child's rights to the special education services under federal law, and there are some services offered by the district under federal law, but they are treated very differently once the parents choose to move them to a private school.
Thank you. And Alan, has that been an issue in Indiana that you're aware of special needs students being denied access to the schools?
I am not aware of any specific case regarding that. I'm not saying that it may not be an issue. It's just there's no case law out there one way or the other that I'm aware of in Indiana.
And I will add that of the 12 states that have school voucher programs, a good number of them have them specifically for special needs students. And so that certainly would probably be less of an issue under that, under those programs. Another question we have is, do any of the voucher programs allow for withdrawal of funding for inadequacy of education, noncompliance with state safety or health, or non-discrimination laws? How is noncompliance by a private school dealt with?
This is Alan from Indiana. Under the Indiana Choice Scholarship Program, if the participating school is a failing school, the state can withhold funding for new students. However, if the student is a current Choice Scholarship participant, they would still receive funding. However, the school would not be able to take in new students.
In Wisconsin, a school can be barred from participating in the program immediately or can be barred from participating in the following year based on violations. I don't think that failure to educate, I don't know how we would measure that. So I don't think that per se could be used as a reason for taking away someone's ability, school's ability to participate in the program. But certainly if they fail to meet the requirements that are set forth in our statutes, like those standards I talked about, or different financial requirements, then they can be barred from the program.
Douglas County, the relationship is a contractual one, so the district is contracted with the private school. And I know that there were some private schools had to show, like I said, a certain level of accreditation. They had to agree to get the state testing, et cetera. And the district is still going to be held responsible for their students' scores on the statewide assessments. So I would assume that those contracts are written in such a way that if the students aren't performing up to a particular level, then the contract won't be renewed.
And I'll add that a number of states with voucher programs do require some sort of accreditation, either from the state or from a regional accreditation organization. And so that would certainly address the inadequacy of education part of that question. And then we have a question of how many of the 12 states that have voucher programs also have open enrollment options, such as students attending schools in any district, as long as those districts have space. And I don't know the answer to that.
We have open enrollment in Wisconsin.
Colorado has open enrollment.
In Indiana, it's up to the school corporation. However, we did do a change this year with regards to cherry picking. So if the school corporation has open enrollment, there are certain requirements that they will have to meet beginning in July. But it's still up to the school corporation if they have open enrollment.
I can certainly get that information. I just don't happen to have it in front of me, but it's a good question. I can certainly send that out to everyone if they're interested. Well, that appears to be our final question. So I want to again thank the speakers for their great presentations and thank everyone for joining in. We will be posting this webinar, including the recording and the PowerPoint, on the NCSL website, certainly for the use of anyone who is unable to attend this webinar and for future resources. So again, thank you, and hope you have a great day.
Thank you. This does conclude today's teleconference. We thank you for your participation. Connect your lines at this time, and have a great day.